The certified letter arrived on a Tuesday morning in late June, and I knew from the fancy HOA letterhead that Barbara Carmichael was about to make my life difficult again. I had moved into my house on Willow Creek Drive in Scottsdale, Arizona, about 8 years ago, long before the Sunset Ridge HOA had annexed our street into their jurisdiction through some bureaucratic maneuvering that still irritated me. My name is Benjamin Jenkins, and I am a 42-year-old software consultant who works from home, which means I have plenty of time to notice when people are trying to pull one over on me. The house I bought was a modest 3-bedroom ranch on a double lot, which gave me a nice buffer from my neighbors and, most importantly, room for the massive oak tree that dominated my backyard. That oak tree was not native to Arizona, which made it even more special. The previous owner had planted it over 50 years ago when he first built the house, hauling in special soil and installing an irrigation system specifically designed to keep the tree healthy in our desert climate. The tree was magnificent, standing nearly 60 feet tall with branches that spread out like a natural canopy over a significant portion of my property and, yes, over the fence line into what was now HOA common area. I tore open the letter with a sense of dread that proved to be entirely justified. Dear Mr. Jenkins, it has come to the attention of the Sunset Ridge Homeowners Association Board that a tree on your property extends over HOA common property, specifically the area designated as Community Playground Zone B. This constitutes a violation of Section 12.4 of the HOA bylaws regarding encroachment of personal property onto communal spaces. You are hereby required to remove said tree within 30 days of receipt of this notice. Failure to comply will result in fines of $250 per day until the violation is remedied. Sincerely, Barbara Carmichael, HOA President. I read the letter 3 times, feeling my blood pressure rise with each pass. Barbara Carmichael was exactly the kind of person who gives HOAs their terrible reputation. She was a 53-year-old woman with a perpetually pinched expression, as if she had been sucking on lemons for the past decade. Her blonde hair was always cut in that specific style that screamed, "I want to speak to your manager." And she drove a white BMW SUV with a bumper sticker that said, HOA board member, protecting your property values. The playground they were referring to had been built 2 years ago on a piece of common land that backed up to my property. Before that, it had just been empty desert scrub that nobody used for anything. The HOA had gotten some grant money from the city and decided to install playground equipment, benches, and a small picnic area. What they had not considered, apparently, was that Arizona summers are brutally hot, and playground equipment made of metal and plastic becomes unusable when exposed to direct sunlight and 110-degree temperatures. My oak tree, with its generous canopy, provided the only significant shade over about 40% of that playground, including the section with the swings and the nicest picnic table. I had noticed families specifically choosing to use that shaded area, and I had felt good about it. My tree was providing a community benefit, and now Barbara wanted me to cut it down. I walked out to my backyard, stepping into the oppressive June heat that hit like a physical wall. The temperature was already 95 degrees at 10 in the morning, and it would climb to at least 108 by afternoon. I stood under my oak tree, enjoying the 20-degree temperature difference its shade provided, and looked over the fence at the playground. 2 mothers were sitting at the picnic table directly under my tree's canopy, watching their kids play on the swings, also shaded by my tree. The rest of the playground sat empty, the equipment too hot to touch, The other benches abandoned because sitting in direct Arizona sun was only slightly less pleasant than sitting in an oven. I pulled out my phone and took several photos, documenting the situation. Then I went back inside to do what I do best: research. The first thing I checked was my property survey, which I had stored carefully in my home office filing cabinet. I spread out the large document on my desk and examined it closely. The survey showed my property lines clearly, and I measured carefully against the scale. My oak tree was planted well within my property boundaries. Yes, the branches extended over the fence, but the trunk and root system were entirely on my land. Next, I pulled up the HOA bylaws that I had saved as a PDF when they first annexed our street. I searched for Section 12.4 that Barbara had cited. It took me a while to find it, buried in subsection after subsection, but when I did, I nearly laughed out loud. Section 12.4. Property owners must maintain their trees and vegetation such that they do not cause damage to HOA common property or interfere with the reasonable use and enjoyment of common areas. The key word was interfere. My tree was not interfering with the reasonable use of the playground. It was enhancing it. Without my tree's shade, a significant portion of the playground was essentially unusable for 4 to 5 months of the year. But I knew Barbara well enough to know that logic and reason were not going to work. She had decided she wanted my tree gone, and she would twist any regulation to make it happen. I needed to understand why. I spent the rest of the day digging through HOA meeting minutes that were posted on their website. The minutes were always dry and boring, which meant most homeowners never read them, but they contained valuable information if you knew what to look for. I found what I was looking for in the minutes from 3 months ago. Board President Carmichael proposed that the HOA investigate installation of a permanent shade structure over Playground Zone B. Estimated cost, $45,000. Board voted to table the discussion pending further research into grant opportunities and assessment feasibility. There it was. Barbara wanted to install an expensive shade structure, but she needed the money to do it. If my tree was not there providing free shade, she could make a stronger case that the shade structure was necessary, potentially justifying a special assessment on all the homeowners to pay for it. I sat back in my chair, thinking. I needed to be strategic about this. I could not just ignore the letter, because then the fines would start accumulating, and the HOA had the legal right to place a lien on my property if I did not pay. But I also was not going to cut down my beautiful 50-year-old tree just because Barbara Carmichael wanted to justify a construction project. I decided my first step would be to show up at the next HOA board meeting and make my case publicly. The meetings were open to all homeowners, even though usually only 10 to 15 people bothered to attend. The next meeting was scheduled for the following Thursday evening at the community center. In the meantime, I consulted with a real estate attorney named Michael Thornton who specialized in HOA disputes. His office was in downtown Scottsdale, and I met with him on Friday afternoon. Michael was in his late 50s, with silver hair and a calm demeanor that immediately put me at ease. I showed him the letter, my property survey, and the relevant HOA bylaws. He studied everything carefully, then looked up at me with a slight smile. "You know who owns the playground property?" he asked. "The HOA," I said. "It is common area." "Actually, that is not quite right," Michael said. HOA common areas in Arizona are owned collectively by all the homeowners. The HOA manages the property, but they do not own it in the traditional sense. Every homeowner in the HOA has a shared interest in that land. "Okay," I said slowly, not quite seeing where he was going. "Tell me, when did you buy your house?" 8 years ago. August 2018. And when did the HOA annex your street? 6 years ago. They did it in 2020 right after COVID started. Most people were not paying attention. Michael nodded. And when was the playground built? 2 years ago. 2024. He leaned back in his chair. Here is what I suspect, and we will need to verify this with a title search. When your street was annexed into the HOA, the property boundaries were established based on the existing legal descriptions. That piece of land where the playground now sits was probably designated as common area at that time. But here is the interesting part. Property rights for trees in Arizona are not always straightforward. He pulled up something on his computer and turned the screen toward me. It showed Arizona Revised Statutes, Section 33-1818. Arizona law recognizes something called tree ownership that extends beyond property lines in certain circumstances, he explained. If a tree's canopy extends over a neighboring property, the tree owner still maintains certain rights to that tree, including the right to refuse to cut it down, as long as the tree is not causing actual damage or creating a hazard. But this is not a neighboring property, I said. It is HOA common land. Exactly, which makes it even more interesting. Because you are a member of the HOA, you have a shared ownership interest in that common land. So in a sense, your tree is extending over property that you partially own. My mind was spinning. So they cannot make me cut it down. They can try, Michael said. But you have several strong defenses. First, the tree is not interfering with the use of the playground. It is enhancing it. Second, you have a potential claim that the tree's canopy provides an easement for shade that has been established through 2 years of continuous use. Third, and this is the nuclear option if you need it, you could argue that the HOA demanding removal of the tree constitutes a taking of your property without just compensation, which could open them up to significant liability. I felt hope rising in my chest. What do you recommend I do? Go to the board meeting. Present your case calmly and rationally. Document everything. If they refuse to back down, we will send them a formal legal response laying out your defenses. Most HOAs will back off when they realize they are on shaky legal ground, especially if pursuing the matter is going to cost them legal fees. And if they do not back off, Michael shrugged, then we go to court, and honestly, I like your chances, but let us hope it does not come to that. Litigation is expensive and time-consuming for everyone involved. I left his office feeling much more confident. I spent the weekend preparing for the board meeting, printing out photos of families using the shaded playground area, researching the cost of the shade structure Barbara wanted to install, and preparing a calm, rational presentation. Thursday evening arrived, and I drove to the community center with a folder full of documentation and a knot of anxiety in my stomach. I had never been much for public speaking, but this was too important to back down from. The community center was a bland, single-story building with a meeting room that could hold about 50 people. When I arrived at 7 o'clock, there were already about 20 homeowners scattered across the folding chairs, which was more than usual. Apparently, word had gotten out that there might be some drama. The board sat at a long table at the front of the room. Barbara Carmichael sat in the center, flanked by 4 other board members. I recognized 2 of them. David Pearson, a retired dentist who mostly just nodded along with whatever Barbara said, and Jennifer Wu, a younger woman who seemed to actually care about the community but was often overruled. Barbara called the meeting to order with several sharp raps of a gavel, which seemed unnecessarily theatrical. "We will begin with the approval of last month's minutes," she said in her clipped, officious voice. "Do I have a motion?" The minutes were approved quickly, and then Barbara moved through several boring items on the agenda. Approval of landscaping contracts, discussion of pool maintenance, a complaint about someone's Christmas lights being left up too long. Finally, she reached the item I had been waiting for. New business. We have an enforcement matter regarding property encroachment at 4782 Willow Creek Drive. She looked directly at me. Mr. Jenkins, I see you are here. Would you like to address the board? I stood up, my folder clutched in my hand, and walked to the front of the room. I could feel everyone's eyes on me. Thank you, Madam President, I said, trying to keep my voice steady. I received the letter demanding that I remove my oak tree, and I am here to respectfully explain why I believe this demand is unreasonable and possibly illegal. I saw Barbara's jaw tighten, but she gestured for me to continue. I laid out my case methodically. I showed the property survey proving the tree was entirely on my land. I displayed photos showing families using the shaded portion of the playground while the unshaded portion sat empty. I quoted the HOA bylaws showing that the tree was not interfering with the reasonable use of the playground. In fact, I continued, the tree is making the playground more usable, not less. Without the shade from my tree, the playground equipment in that section becomes dangerously hot during summer months. Metal slides and swings can reach temperatures of over 160 degrees in direct sunlight. The shade my tree provides is not just a convenience, it is a safety feature. I saw several homeowners nodding, and Jennifer Wu was taking notes. Furthermore, I said, I've consulted with a real estate attorney who has informed me that under Arizona law, I have certain rights to my tree even where the canopy extends beyond my property line, especially when the tree is not causing damage and when the neighboring property is HOA common land in which I have a shared ownership interest. Barbara's face had gone red. Mr. Jenkins, the board has determined that the tree constitutes an encroachment and must be removed. The HOA has the authority to enforce its bylaws. With respect, Madam President, I disagree with the board's interpretation of the bylaws, I said. The tree is not interfering with the use of the playground. If anything, this is a dispute about whether the board has the authority to demand removal of a tree that is providing a community benefit simply because the board wants to justify installing an expensive shade structure instead. There was a murmur from the assembled homeowners. Barbara shot me a venomous look. That is a baseless accusation, she snapped. This has nothing to do with any proposed shade structure. Then why are you demanding removal of the only significant shade source over the playground? I asked calmly. The tree is healthy, it is not diseased, it is not dropping dangerous branches, and it is not interfering with any utilities or structures. The only thing it is doing is providing free shade that your shade structure would cost $45,000 to replicate. That is enough, Mr. Jenkins, Barbara said, her voice sharp. The board has made its decision. You have 30 days to comply or you will face fines. Then I am formally notifying the board that I will not be removing the tree, and if the HOA proceeds with fines, I will challenge them through the proper legal channels, I said. I have documented everything, and I am prepared to defend my property rights. I returned to my seat, my heart pounding. The rest of the meeting passed in a blur. When it was time for homeowner comments, 3 different people stood up to say they loved the shade from my tree and did not want it removed. One woman, Sandra Martinez, who had 2 young kids, said she would not even bring her children to the playground during the summer if not for that shaded area. Barbara tried to maintain control, but I could see she was rattled. The meeting adjourned, and several homeowners came up to me afterward to express their support. Jennifer Wu, the board member who seemed reasonable, approached me as I was leaving. "Mr. Jenkins, I want you to know that the vote on this enforcement action was not unanimous," she said quietly. "I voted against it. I think Barbara is pursuing this for the wrong reasons." "I appreciate that," I said. "Do you have any advice for how to handle this?" She glanced around to make sure Barbara was not in earshot. "Document everything. Every interaction, every letter, every conversation. Barbara can be vindictive and she does not like to lose. But she also does not like expensive legal battles that make her look bad. If you stand firm and show you are serious about fighting this, she might back down." "Thank you," I said sincerely. Over the next 2 weeks, I heard nothing from the HOA, and I started to hope that my presentation at the board meeting had been enough. But then, exactly 30 days after the original letter, I received another certified letter. "Dear Mr. Jenkins, as you have failed to comply with the HOA's directive to remove the tree at 4782 Willow Creek Drive, you are now in violation of HOA bylaws. Fines in the amount of $250 per day will begin accruing as of tomorrow's date. You have 10 days to cure this violation before the HOA will proceed with placing a lien on your property." I called Michael Thornton immediately. "They are serious about this," I told him. "What do we do?" "Now we send our formal response," Michael said. "I will draft a letter laying out your legal position and making it clear that if they proceed with the fines, you will take them to court and seek damages for harassment and abuse of HOA authority. That usually gets their attention." Michael's letter was a thing of beauty. It was 5 pages of dense legal argument, citing case law and Arizona statutes, methodically dismantling every aspect of the HOA's position. The key paragraph stated, "Should the HOA proceed with fines and a lien against Mr. Jenkins' property, Mr. Jenkins will have no choice but to file suit in Maricopa County Superior Court seeking declaratory relief, injunctive relief, and damages for abuse of HOA authority under Arizona Revised Statutes, Section 33-1807. Mr. Jenkins will also seek attorney's fees and costs. Furthermore, Mr. Jenkins reserves the right to pursue claims for intentional interference with property rights and potential violations of Arizona's consumer fraud statutes, if it can be demonstrated that this enforcement action is pretextual and designed to further other HOA objectives." We sent the letter via certified mail and email to ensure the board received it promptly. The response was not what I expected. Instead of backing down, Barbara doubled down. 3 days after receiving Michael's letter, the HOA sent me a notice that I was being fined $250 per day, and that the total fine currently stood at $750. They also scheduled a hearing before the board to determine whether to proceed with a lien. "This is crazy," I told Michael on the phone. "She is willing to take this all the way to court over a tree." "Some people are just like that," Michael said. "Their ego gets invested, and they cannot back down even when it is in their best interest to do so. Okay, here is what we are going to do. We are going to file a lawsuit before they can place a lien on your property. We will ask the court for a preliminary injunction stopping the HOA from assessing fines or placing a lien while the case is pending." "How much is this going to cost me?" I asked, dreading the answer. "I will be honest with you, Benjamin. Litigation is expensive, but I think we have a strong enough case that I am willing to take it on a partial contingency basis. You pay my filing fees and costs, and if we win, I will seek attorney's fees from the HOA as the prevailing party. If the court awards fees, which they often do in HOA cases when the HOA is clearly in the wrong, then you will be made whole. And if we lose, Then you are out my costs and you will have to deal with the HOA's demands, but I do not think we are going to lose. I took a deep breath. Okay. Let us do it. Michael filed the lawsuit in early August. The case was styled Benjamin Jenkins v. Sunset Ridge Homeowners Association, Inc., and it was assigned to Judge Richard Morrison in the Maricopa County Superior Court. The complaint was comprehensive. It alleged that the HOA was violating Arizona statutes governing HOA authority, that the tree removal demand was pretextual and designed to justify an expensive construction project, and that the HOA was abusing its enforcement powers. We asked the court for a declaratory judgment that the tree did not violate HOA bylaws, an injunction preventing the HOA from assessing fines or placing a lien, and attorney's fees. When the HOA received the complaint, they were required to respond, and they hired their own attorney, a firm that specialized in representing HOAs. The attorney, Robert Kendrick, filed a motion to dismiss the case, arguing that I had not exhausted the HOA's internal dispute resolution procedures before filing suit. Michael filed an opposition brief arguing that the internal dispute resolution process was futile because the board had already made clear they were not going to change their position, and that I would suffer irreparable harm if forced to wait while fines continued to accumulate. Judge Morrison scheduled a hearing on the preliminary injunction for late September. I took the day off work and met Michael at the courthouse downtown. It was an imposing building, and I felt nervous as we went through security and took the elevator up to the courtroom. The courtroom was smaller than I expected, with seats for maybe 30 spectators. Barbara Carmichael was there with the HOA's attorney, Robert Kendrick, a sharp-faced man in an expensive suit. When Judge Morrison took the bench, he was a serious-looking man in his early 60s with wire-rimmed glasses. He had clearly read all the briefs because he got straight to the point. "Counsel, I have reviewed the pleadings and the parties' briefs. Mr. Thornton, your client is asking me to enjoin the HOA from enforcing what it claims is a legitimate bylaw. That is a significant request. What is your best argument for why I should grant this relief?" Michael stood. "Your Honor, our best argument is that the HOA bylaw in question requires that trees not interfere with the reasonable use and enjoyment of common areas. The undisputed evidence shows that Mr. Jenkins' tree enhances the use of the playground by providing shade during Arizona's extreme summer heat. Without that shade, approximately 40% of the playground is unusable for 4 to 5 months of the year. The HOA is attempting to enforce a bylaw in a way that contradicts its plain meaning, and we believe this is being done to justify a proposed $45,000 shade structure project. Mr. Jenkins will suffer irreparable harm if fines continue to accrue while this case proceeds." Judge Morrison turned to the HOA's attorney. "Mr. Kendrick, how do you respond?" Kendrick stood smoothly. "Your Honor, the HOA has broad authority under Arizona law to enforce its bylaws. The bylaw at issue prohibits encroachment onto common property. Mr. Jenkins' tree extends over the fence line onto HOA property. That is an encroachment. The HOA has the authority to demand its removal. Whether the tree provides shade is irrelevant to the legal question of whether it constitutes an encroachment." "But does the bylaw actually prohibit all encroachments, or does it prohibit encroachments that interfere with reasonable use?" the judge asked. Kendrick hesitated for just a moment. "The bylaw should be read to prohibit all unauthorized encroachments, Your Honor." "That is not what the bylaw says, though, is it?" Judge Morrison said, flipping through the papers in front of him. "The bylaw specifically states that trees must not interfere with reasonable use. That is not a blanket prohibition on encroachment. I felt a surge of hope. The judge was seeing through the HOA's arguments. "Your Honor," Kendrick said, "even if we accept that interpretation, the HOA board has the authority to determine what constitutes interference with reasonable use. The board has made that determination here." "Does the board have unlimited discretion to make that determination, even if it is arbitrary or capricious?" the judge asked. "Within reason, yes, Your Honor." Judge Morrison leaned back in his chair, thinking. The courtroom was silent. "Here is what troubles me about the HOA's position," the judge finally said. "The undisputed evidence shows that this tree provides significant shade over a playground in Arizona's summer heat. That shade makes the playground more usable, not less. The HOA's demand for removal appears to be arbitrary at best and pretextual at worst. I am inclined to grant the preliminary injunction, but I am going to give the parties one opportunity to resolve this through mediation before I issue a formal order. I am appointing a mediator, and you will have one mediation session within the next 30 days. If mediation fails, I will issue the injunction and this case will proceed to trial. Are we clear?" Both attorneys nodded. "Good. My clerk will contact you with the mediator assignment." We are adjourned. As we left the courtroom, I felt like I could breathe again. "That went well," Michael said. "The judge clearly sees this our way. The HOA would be smart to settle now." "Do you think they will?" I asked. "Depends on how reasonable they want to be." Barbara Carmichael does not strike me as a particularly reasonable person, but their attorney will advise them about the risks of proceeding. The mediation was scheduled for late October at the mediator's office in Tempe. The mediator was a retired judge named Patricia Hoffman, who had a reputation for being tough but fair. I arrived at the mediation with Michael, and we were shown to a conference room. Barbara Carmichael arrived with Robert Kendrick and 2 other board members, David Pearson, and a man I did not recognize. Judge Hoffman explained the mediation process. Each side would have a chance to present their position, and then she would work with us separately and together to try to reach a resolution. Barbara went first, and she was clearly still angry. "This man is refusing to follow HOA rules," she said, her voice tight. "Everyone else in the community has to follow the rules, but he thinks he is special. The tree is an encroachment onto common property, and it needs to be removed. If we let him get away with this, it sets a precedent that anyone can violate the rules." When it was my turn, I kept my voice calm. "I am not trying to violate any rules," I said. "I am trying to protect a beautiful 50-year-old tree that is providing a valuable benefit to the community. The playground is more usable with the tree than without it. This is not about breaking rules. It is about interpreting rules reasonably. I am willing to work with the HOA on any legitimate concerns they have about the tree, but I am not going to cut it down just because Miss Carmichael has decided she wants it gone." Judge Hoffman listened carefully to both sides, then sent us to separate rooms. She spent about an hour going back and forth between the rooms, trying to find common ground. Finally, she came to our room and sat down with a tired expression. "I am going to be honest with you," she said. "The HOA is not in a reasonable frame of mind right now. Miss Carmichael is fixated on the idea that you are defying her authority, and she is not willing to consider any compromise that leaves the tree standing. I have tried to explain to her that a judge is very likely to rule in your favor, but she does not want to hear it." "So what do we do?" I asked. "You can make one final offer, and if they reject it, we will end the mediation and you will proceed to trial." "What are you willing to offer?" Michael and I discussed it quietly. "I am willing to sign an agreement taking responsibility for any damage the tree might cause to the playground area," I said. I am willing to pay for regular professional inspections to make sure the tree stays healthy and safe. I am even willing to pay for liability insurance that names the HOA as an additional insured, but I am not cutting down the tree. Judge Hoffman took that offer to the other room. She came back 20 minutes later shaking her head. They rejected it. Miss Carmichael says the only acceptable resolution is complete removal of the tree. I am sorry, gentlemen. We are at an impasse. The mediation ended and we went back to court. Judge Morrison issued his preliminary injunction in early November, ordering the HOA to cease all fines and to refrain from placing any lien on my property while the case proceeded. The judge also ordered an expedited trial schedule, with trial set for February. The HOA could have appealed the preliminary injunction, but apparently their attorney advised against it. The fines stopped, and I had a few months of relative peace while both sides prepared for trial. During those months, I noticed something interesting. The word had spread throughout the community about the lawsuit, and I started receiving a lot of support from other homeowners. Several people stopped by my house to tell me they thought the HOA was being ridiculous. A few even offered to testify on my behalf about how much they valued the tree's shade. I also discovered something else interesting while preparing for trial. Michael subpoenaed the HOA's financial records and meeting minutes as part of discovery, and buried in those documents was an email exchange between Barbara Carmichael and a construction company that specialized in shade structures. The email was dated 2 weeks before I had received the original demand letter about my tree. In it, Barbara asked the construction company for a quote on a shade structure over the playground. The construction company responded with a quote for $48,000 and a note. We recommend removing the existing tree cover first to allow for optimal placement of the shade structure. That email was the smoking gun. It proved that Barbara had been planning to remove my tree to make way for her shade structure project before she had even sent me the enforcement letter. The whole thing about HOA bylaw violations was just a pretext. When I saw that email, I got angry all over again. This was not about rules or property values or community standards. This was about Barbara Carmichael wanting to spend HOA money on an expensive construction project, and my tree was in the way of her plans. Michael planned to make that email a centerpiece of our trial strategy. As we got closer to trial, the HOA made one more attempt to settle. In January, Robert Kendrick called Michael with an offer. The HOA would drop all demands for tree removal and withdraw the fines if I would agree to pay $5,000 toward the cost of installing shade structures over the unshaded portions of the playground. It was a tempting offer. $5,000 was a lot less than the potential cost of going through a full trial, even if we won. But there was a principle at stake now, and I was tired of being pushed around. Tell them no, I said to Michael. I am not paying them anything. They started this fight, and if they want to end it, they can drop everything unconditionally. Otherwise, we go to trial. Michael conveyed my response, and we heard nothing back. The trial began on February 9th. It was held in the same courtroom where we had had the preliminary injunction hearing. Jury trials were available in civil cases, but both sides had agreed to a bench trial, meaning Judge Morrison would decide the case himself. The trial lasted 3 days. On the first day, Michael presented our case. I testified about the history of the tree, the benefits it provided to the community, and my willingness to take responsibility for maintaining it safely. We also called Sandra Martinez, the mother of 2 who had spoken at the HOA meeting, to testify about how her family used the shaded portion of the playground. We go to the playground almost every day in the summer, Sandra testified. But we can only use it in the early morning or late evening unless we stay in the shaded area. The metal equipment gets so hot in the direct sun that it can burn my kid's skin. That tree makes it possible for us to use the playground during the day. We also called an arborist who testified that the tree was healthy, properly maintained, and posed no safety hazard. He said the tree could easily live another 50 years with proper care. On the second day, the HOA presented their case. Barbara Carmichael testified, and she was combative from the start. "The issue here is simple," she said when Robert Kendrick questioned her. "Mr. Jenkins' tree extends onto HOA property without permission. That is a violation of our rules. If we allow one homeowner to violate the rules, then everyone will think they can violate the rules." When Michael Cross examined her, he went straight for the throat. "Miss Carmichael, is it true that you solicited quotes for a shade structure over the playground before you sent Mr. Jenkins the letter demanding tree removal?" Barbara's face flushed. "I may have made some preliminary inquiries." "And is it true that the construction company recommended removing the tree to make way for the shade structure?" "I do not recall the specifics of that conversation." Michael pulled out the email and showed it to her. "Does this refresh your recollection?" Barbara read the email, and I could see her jaw clench. This was just preliminary research. It had nothing to do with the enforcement action against Mr. Jenkins. "Really? Because the email is dated 2 weeks before the enforcement letter was sent. That seems like more than a coincidence." "I was exploring options for improving the playground. That is part of my job as HOA president. And removing Mr. Jenkins' tree would have made it easier to install your $48,000 shade structure, would it not?" "Objection, Your Honor," Robert Kendrick said. Argumentative. "I will allow it," Judge Morrison said, looking interested. "Please answer the question, Miss Carmichael." "I suppose it might have made the installation easier, but that was not the reason for the enforcement action," Barbara said, but her voice lacked conviction. Michael pressed on. "How many other homeowners have you sent enforcement letters to regarding trees that extend over property lines?" "I do not have that number in front of me." "Would it surprise you to learn that in the past 5 years, the HOA has sent exactly 0 enforcement letters regarding tree encroachment other than the one sent to Mr. Jenkins?" Barbara shifted uncomfortably. "Every situation is different. So Mr. Jenkins' situation is unique." "What makes it unique?" "His tree extends significantly onto HOA property. But it is providing shade that makes the playground more usable, correct? That is a matter of opinion. Is it your opinion that the playground is more usable with less shade?" Barbara did not answer, and Judge Morrison instructed her to respond. "I think the playground would be fine with or without the tree," she finally said. "Even though the metal equipment reaches temperatures of over 160 degrees in direct sunlight. Parents can choose to use the playground in the morning or evening when it is cooler. Or they can use it during the day in the shaded area provided by Mr. Jenkins' tree, correct, I suppose?" Michael let that answer hang in the air for a moment before moving on. The rest of the HOA's case was weak. They called a board member who testified that they were just trying to enforce the rules fairly. But on cross-examination, the board member admitted he had not even looked at the tree in person before voting to demand its removal. On the third day, both sides presented closing arguments. Michael's closing was powerful. "Your Honor, this case is about whether an HOA can abuse its authority to demand removal of a beautiful, healthy tree that is providing a significant community benefit, solely because the HOA president wants to justify an expensive construction project. The evidence shows that Ms. Carmichael was planning to remove this tree before she ever sent the enforcement letter. The evidence shows that the tree makes the playground more usable, not less. And the evidence shows that the HOA has never enforced this rule against any other homeowner. This is selective enforcement designed to achieve a pretextual goal, and it should not be allowed. We ask the court to enter judgment in Mr. Jenkins' favor, to permanently enjoin the HOA from demanding tree removal, and to award attorney's fees. Robert Kendrick's closing focused on HOA authority and rule enforcement, but even he seemed to know it was a losing argument. Judge Morrison took the case under advisement and said he would issue a written ruling within 30 days. The waiting was excruciating. Every day I checked the court's online docket to see if a ruling had been filed. Michael told me not to obsess over it, but I could not help myself. Finally, on March 5th, the ruling appeared. It was a comprehensive 23-page decision that methodically addressed every issue in the case. The key findings were exactly what we had hoped for. The court finds that the HOA's demand for tree removal was pretextual and not based on a good faith interpretation of HOA bylaws. The evidence clearly shows that the tree enhances, rather than interferes with, the reasonable use of the playground. The court further finds that the HOA engaged in selective enforcement, as it has never enforced this bylaw against any other homeowner. The court finds that the email evidence establishes that the true motivation for the enforcement action was to facilitate installation of a shade structure, not to address any legitimate bylaw violation. Accordingly, the court enters judgment in favor of plaintiff Benjamin Jenkins. The HOA is permanently enjoined from demanding removal of the tree or assessing any fines related to the tree. The court further awards attorney's fees and costs to plaintiff as the prevailing party. A separate order regarding the amount of fees will be entered after appropriate briefing. I read the ruling 3 times, hardly believing it. I had won. The tree was safe and the HOA would have to pay my attorney's fees. I called Michael immediately. "We won," I said, probably too loudly. "I know," he said, and I could hear the smile in his voice. "I told you we had a good case." "Congratulations, Benjamin. You stood up for your rights and it paid off. What happens now?" "Now I file a motion for attorney's fees. I will submit my billing records and the court will determine what is reasonable. Given that we won on every issue, I expect the court will award most or all of my fees. The HOA will have to pay. What about Barbara? Will there be any consequences for her? That is up to the HOA membership. If homeowners are upset about the HOA wasting money on frivolous litigation, they can vote her out at the next election. But that is not something we can control. Over the next few weeks, word of the court ruling spread through the community. I received congratulations from neighbors, many of whom told me they were tired of Barbara's authoritarian approach to running the HOA. In April, Michael filed his motion for attorney's fees, requesting $32,000, which represented his time spent on the case at his standard hourly rate. The HOA filed an objection, claiming the amount was excessive, but Judge Morrison awarded the full amount in May. That meant the HOA had spent over $32,000 on a legal battle they lost, money that could have been spent on actual community improvements. I heard through the grapevine that many homeowners were furious. The HOA annual meeting and board elections were held in June, exactly 1 year after I had received the original letter demanding tree removal. I attended the meeting out of curiosity. The community center was packed. Nearly 100 homeowners showed up, which was unprecedented. The annual meeting usually drew maybe 20 people. When it came time for board elections, 3 different homeowners stood up to nominate candidates to run against Barbara Carmichael for HOA president. Barbara looked increasingly uncomfortable as speaker after speaker criticized her handling of the tree dispute and the waste of HOA funds on unnecessary litigation. When the votes were counted, Barbara had lost. The new HOA president was Jennifer Wu, the board member who had supported me from the beginning. Barbara left the meeting quickly, her face red with anger and humiliation. Jennifer approached me after the meeting. "Thank you for standing up to her," she said. "A lot of people were afraid to challenge Barbara, but you showed it could be done. I promise we are going to run this HOA differently going forward." "I appreciate that," I said. "I never wanted to be in a war with the HOA. I just wanted to keep my tree. And you should keep your tree. It is a valuable asset to the community. Actually, I have been thinking about something. Would you be willing to grant the HOA a formal easement for the tree's canopy over the playground? In exchange, the HOA would agree to help pay for professional tree maintenance and would name you as an additional insured on the HOA's liability policy. That way everyone benefits and we formalize the arrangement." I thought about it. "That seems fair. Let me run it by my attorney, but I think we can work something out." And we did. In July, the HOA and I signed an agreement creating a permanent easement for the tree canopy over the playground. The HOA agreed to contribute $500 per year toward professional tree maintenance, and I was added to the HOA's liability insurance. The agreement also specified that the tree could not be removed without my consent, except in cases of genuine safety emergencies. It was a reasonable compromise that should have been reached a year earlier, before anyone spent tens of thousands of dollars on legal fees. Life settled back into a normal rhythm after that. I continued working from home, and I took extra care to maintain the oak tree properly. I hired an arborist to come out twice a year to inspect the tree, trim any potentially hazardous branches, and ensure the tree stayed healthy. The playground remained popular, especially the shaded section. On hot summer days, I would look out my back window and see families gathered under my tree, kids playing on the swings and climbing equipment, parents sitting at the picnic table. It made me happy to know the tree was serving a purpose beyond just beautifying my yard. Barbara Carmichael stayed in the community but kept a much lower profile after losing the board election. I saw her occasionally at community events, and we exchanged polite nods but never spoke. I heard she eventually sold her house and moved to a different subdivision in Scottsdale, one where presumably she could find a new HOA board to join. Jennifer Wu proved to be an excellent HOA president. She focused on genuine community improvements, like repairing the pool equipment and organizing neighborhood social events, rather than on petty enforcement actions. The community became a more pleasant place to live. As for me, I learned an important lesson from the whole experience. Sometimes you have to stand up for what is right, even when it is expensive and stressful and would be easier to just give in. Property rights matter. Trees matter. Community matters. And people like Barbara Carmichael only have as much power as we give them. My oak tree still stands tall in my backyard, its branches spreading out in a generous canopy that provides shade and beauty. On especially hot summer afternoons, I sometimes sit in one of my patio chairs beneath those branches, enjoying the 20-degree temperature difference the shade provides, and I think about how close I came to letting the HOA bully me into cutting it down. I am glad I fought back. The tree will probably outlive me, and when I eventually sell this house and move on, the tree will still be here, providing shade for whatever family comes next. And it will still be spreading its branches over that playground, giving kids a cool place to play during Arizona's brutal summers. That is worth fighting for. In August, about a year and 2 months after the whole ordeal began, I was working in my home office when my doorbell rang. I answered it to find a couple in their 30s with a young daughter, maybe 5 years old. "Hi," the man said. "I hope we are not bothering you. We are looking at houses in the neighborhood, and our realtor told us about your oak tree and the whole HOA situation. We just wanted to see the tree in person." I smiled. "You are not bothering me at all. Come around to the backyard." I led them through my side gate, and their faces lit up when they saw the massive oak tree. "Wow," the woman said. "It is even more beautiful than our realtor described." Their daughter ran over to the fence and pointed at the playground. "Can we go play there, Mommy?" "In a bit, sweetie," the mother said. "Our realtor said you fought the HOA to keep this tree," the man said. "That must have been stressful." "It was," I admitted, "but it was worth it. This tree is special." "We have been looking at houses in a lot of HOA communities," the woman said, "and honestly, most of them make us nervous. HOAs can be so controlling. But when our realtor told us about what happened here, and how the community actually voted out the bad board members and made changes, we thought that showed this was a different kind of place." "I think it is," I said. "We have good people here now running the HOA. People who care about the community, not just about enforcing rules for the sake of rules." They thanked me and left, and I went back to work feeling good. The story of my fight with the HOA had become part of the neighborhood's identity. A cautionary tale about HOA overreach, but also an encouraging story about how communities can push back and make changes. In September, Jennifer Wu asked if I would be willing to serve on the HOA's newly formed Community Enhancement Committee. The committee's job was to identify projects that would genuinely improve quality of life in the neighborhood, as opposed to the expensive vanity projects Barbara had favored. I agreed, and over the next several months we worked on a variety of initiatives. We organized a neighborhood tree planting day, with the HOA providing free native trees to any homeowner who wanted one. We installed better lighting along the walking paths. We created a community garden where residents could grow vegetables. And yes, we eventually did install some shade structures over the unshaded portions of the playground, but we did it intelligently. Instead of spending $48,000 on elaborate structures, we found a company that installed simple, effective shade sails for $12,000. They complemented my oak tree rather than competing with it, and now the entire playground had good shade coverage. One evening in October, I was having dinner with some friends when one of them asked me if I regretted going through the whole legal battle with the HOA. I thought about it carefully before answering. "No," I finally said. "I do not regret it at all. It was stressful and expensive, even though I eventually got my attorney's fees back. But if I had just caved and cut down the tree, I would have regretted that for the rest of my life. That tree is not just a tree to me. It represents standing up for what is right, not letting bullies push you around and fighting for things that matter. Those are principles I want to live by." My friends nodded, understanding. As the seasons changed and another year passed, the oak tree continued to thrive. The arborist who inspected it told me the tree was in excellent health and could easily live another 100 years with proper care. I thought about all the people who would benefit from that tree's shade over the next century, all the kids who would play under its branches, all the families who would gather beneath its canopy on hot summer days. Barbara Carmichael had wanted to cut down that tree to make way for an expensive construction project, and to prove she had the authority to enforce HOA rules, no matter how unreasonable. She had been willing to destroy something beautiful and beneficial for the sake of her ego and her agenda. But she had lost. The tree stood. The community was better for it. And I had learned that sometimes the most important thing you can do is refuse to back down when you know you are right. That is the story of how I fought my HOA over a tree and won. It is a story about property rights, community values, the importance of standing up to bullies, and the value of having a beautiful old oak tree that provides shade for everyone to enjoy. The tree stands tall in my backyard to this day, its branches reaching out toward the Arizona sky, its leaves rustling in the hot desert wind, its shade providing a cool refuge for anyone who needs it. And every time I look at that tree, I remember the fight it took to save it, and I am grateful I did not back down. Some things are worth fighting for. A 50-year-old oak tree that provides shade and beauty to an entire community is definitely one of those things. And the principle that HOAs should not be allowed to abuse their authority to destroy valuable community assets just to serve the agendas of petty tyrants is another. I won that fight, and the community is better off because of it. That is all I ever wanted.